We're going to go to Joshua Schiffer, who is a practicing attorney and a legal expert. Joshua, you've joined us a few times before. We're glad to have you back. I know you have been following what's been going on inside this Barrow County Superior Courtroom today. What have been the moments that have caught your attention so far?
There's been so many specific junctures where a specific individual juror could connect to the point being made, or can connect to that moment of testimony and bring it back and get comfort from it because of a shared experience. And that's really the goal of the state right now, to end this overwhelming, arguably cumulative presentation of the factors presented to Colin Gray by third parties, by his family, by the school, that they're hoping that someone's going to go back in that jury room and say, "Yep, I'm satisfied. Colin Gray was the last and best person. He was thoroughly warned by these various stakeholders, and therefore we are comfortable holding him criminally responsible for the actions that his son Colt Gray then allegedly took," which is, of course, the novelty of this prosecution. The watching the video yesterday, I believe, was probably a top five moment in the case, because you're seeing the revelation of Colin Gray telling his story really land with him for the first time. And you hear words coming out of his mouth that he immediately recognizes during both that interview and then obviously watching it replayed in open court are extraordinarily inculpatory, showing how much information he had. And even, I bet, to himself and his own legal team, they go, "Man, that's a bad look right there. I don't know how we're going to get away from that with the presentation we're expecting from the defense, should they choose to put on a case." Um, that video was very powerful. And then, of course, today, seeing all of the writings that have been laboriously gone through, the timeline and the messaging, like Grace was explaining, that's the kind of evidence that's very easy for a juror to write down in their notebook, get connected with, and believe. Use that information during the deliberative process in order to hold tight to the narrative that the state wants them to support. How the defense counters this, I'm very eager, because Mr. Hobbs and Mr. Barry are two of the best lawyers in Georgia, and I know they've spent an enormous amount of time game planning the right approach for this jury.
And let's talk about that, Joshua, because at some point, the state's going to rest their case, the defense is going to present their case, and then we're going to have closing. What do you anticipate we'll hear from both prosecutors and the defense attorneys you just mentioned when they make their closing arguments to the jury?
So it goes back to really the overall theme of what the defense is going to go with. And the good news about this case for the defense is, clearly, they don't have the burden. The American judicial process requires the state to carry that burden. That burden's unwaivable. It can shift, but really the state has to prove the charge beyond a reasonable doubt. That charge will be explained to the jury in detail by the court after the charge conference, before they begin deliberations. So how the defense wants to pose the justifications why a juror could not convict or should not convict can be multifaceted. They don't have to stick to one reason. An advantage of the defense is that you can cleave out multiple arguments, and as long as those arguments eventually land with 1, 2, 3, 4, 5 jurors, that's a win for the defense. And it's absolutely possible for part of the defense's argument to land differently with different jurors. I expect the defense to focus initially on the other people involved and how other people took the same actions that are apparently criminal for Colin Gray. People that didn't take action, people that didn't step forward. We've seen law enforcement appear at the house. Why didn't they do more? We've seen the school, many schools, many people at the schools all talk at length about how Colt Gray had the red flags and they did what school employees do. But is that enough? And how does that fit into the request of the state to convict someone? juries have two overriding fears in every single case: wrongful conviction and wrongful acquittal. And jurors want to avoid those, and they value them very strongly. In this case, I could see the defense making really good arguments involving the fear of incarcerating someone merely for owning a firearm. Colin Gray didn't pull any triggers. Colin Gray didn't go to the school and personally harm someone, which is generally the threshold for committing a crime against the person in the state of Georgia.
And you get into this, Joshua, but in a lot of ways, this case is about inaction. The state arguing that by not proactively taking more steps, Colin Gray veered into the realm of criminal responsibility. And that's a bit of a novel legal theory, right?
You're absolutely right, Zach. And that really, where else does the government require you to do something proactive, like you're talking about? Government has lots of prohibitions. Laws are very good at prohibiting things. But to actually force you to do something, very rare, if not absent entirely in the criminal justice system. And that's why this is so novel. And then you sprinkle on the fact that we're talking about Second Amendment rights, an amendment that, not to value one amendment more than the other. It's a favorite here around Georgia. We love our guns, and there are a lot of people who are rightfully concerned anytime a crime can be ascribed to an individual where they chose not to do something or didn't take an affirmative act, and it involves the possession or provisioning of a firearm. So this is getting watched nationally.
And Joshua, we have time for one last question, very briefly. But if there is a conviction, and I want to be extremely clear as I ask this question, that decision is up to the jury. We do not know how this is going to go at the trial court level. If there is a conviction, what are the odds that this ends up going up on appeal and remains being litigated in the Georgia appellate system for some time?
Yeah, I'm not very good at short answers, but I'll do my absolute best. And you're right. The jury has the exclusive province of determining guilt or innocence in following the court's instructions. And I am 99.9% sure some portion of this case will be appealed regardless of the verdict.
Joshua Schiffer, we always appreciate your time and your insight. We know you're going to continue to watch this case closely, as we do as well. Thanks for your time as always. Thank you.
Thanks so much, Zach. Everybody have a great day, and thanks for watching this case. This is history being made.